So the next real bugaboo on this is expert witnesses. You'll get every kind possible to show that there's a grave risk of harm, or even to show there were human rights violations in the other country. I had a case involving South Africa in the days of apartheid, and they brought in an expert before Commissioner Klein showing that children who had burning tires around their neck, and they made it into this dog and pony show that went on forever about human rights violation, and the judge allowed it over my objection. But that's what you want to fight in. Experts, I think Sanchez will help you on this, prevent experts from coming in and testifying on things they really shouldn't be testifying about it. What do you do on experts? Have you had experts in these cases?
I've had experts. I think that most, I mean, one of the things that lawyers don't get, just because evidence is presented doesn't mean it has much weight. So, in fact, the worst thing that can happen to you as a lawyer is when the judge is overruling every single one of the other guy's objections. If that's happening to you, ain't a good day for you. So, you know, a lot of judges, I think, will err toward letting things in. I'm going to talk about the defense in a second. But I've had experts come in, not many, but I certainly have had them come in.
Marina.
Okay, so before you file a petition under the Hague Convention to get relief for the return of the child, you have to make sure that 4 elements are established. You have to make sure that the removal was wrongful or the retention was wrongful. You have to make sure that the movement is international, so you can't file a Hague petition when there is an abduction in the United States between states.
Give us a year. That may be
Who knows? You have to also make sure that the countries are signatories to the Hague Convention. For example, there was a case, U.S. versus Amer, for those who are interested, I have citations, where the father couldn't get relief under the Hague Convention for children who were abducted to Egypt because Egypt wasn't a signatory to the Hague Convention. And finally, when you're seeking the return of a child that has been wrongfully removed or wrongfully retained, the child has to be under the age of 16 years old. So, assuming all of those elements are in place, the next thing you do is file a petition. And when you file a petition, you have to prove your case for the return of the child by a preponderance of evidence. And the Hague Convention provides that if you prove your case, a prima facie case, by a preponderance of evidence, then the child must be returned unless the respondent can assert and prove some of the affirmative defenses that Judge Gordon is going to go into detail on. Importantly, the burdens of proof change depending on whether you're the petitioner or the respondent, or even if you're the respondent, depending on what type of affirmative defenses you are alleging. So if you are the petitioner asking for the return of the child that has been wrongfully removed or retained in a foreign country, you have to establish your case by a preponderance of evidence. If you are the respondent asserting affirmative defenses, then depending on what affirmative defenses you assert, you have to prove your case either by clear and convincing evidence or by a preponderance of evidence. For example, if you are alleging an affirmative defense under Articles 13b or Articles 20 of the Convention, those include grave risk of harm that has been previously discussed, such as physical or psychological harm, or you're alleging some fundamental freedom defense or basic human rights defense. That burden of proof is clear and convincing. If you are asserting affirmative defenses under Articles 12 and 13 of the Convention, these include more often the consent defense or the objection of the mature child defense, or the well-settled defense, then your burden of proof is preponderance of evidence. So you file the petition, and now you must prove your prima facie case. There are 3 elements that you must prove to establish your prima facie case for the return by preponderance of evidence. The first is that the removal or the wrongful retention of the child happened in a foreign country where the child was a habitual resident. And I'll go through all of these elements one by one, but give you a brief summary. You have to establish that the removal was a breach of custody rights, and Peter is going to go into detail as to that element. And you have to establish that at the time of the wrongful removal or the wrongful retention, that the petitioner was exercising his or her custodial rights. And as I've mentioned before, the child has to be under the age of 16. Habitual residence is not defined specifically by the Hague Convention, and there's no time frame or a definition provided. However, there are several cases that shed some light as to how judges can determine the habitual residence of a child that has been wrongfully removed or wrongfully retained. The courts are instructed to make a factual determination as to the child's habitual residence based on the totality of circumstances involved. And the reason why judges are instructed to make factual determinations is so that there is uniformity between the foreign countries that are signatories to the Hague Convention and to avoid inconsistencies. There is one case that is very informative on the determination of the habitual residence of the child, and that's the case of Moses v. Moses. In that case, father appealed the decision of the U.S. District Court for the Central District of California, denying his petition to have 3 of his children returned to Israel. And in that particular case, the court goes through a history of cases where habitual residence was identified and the elements that go into habitual residence were identified. The case that is most cited on habitual residence, which is referenced in Moses, is the case from 1989 High Court of In re Bates, in which case the court determined that when you're determining habitual residence, you have to look at the settled intent. And when you look at whether the child is settled in a particular place, it's neither general nor specific, but there has to be some degree of continuity that can be described as well settled in a particular place. The concept of habitual residence is a fluid concept, and it changes from case to case depending on what the facts of the case are. But even though the factors change, some of the most often considered factors are changes in the physical location, the location of a child's possessions, passage of time. And with the passage of time, this is something that Judge Gordon briefly touched upon. That's why it's so important, if you are going to file a petition, to do so within a 6-week period of time. Also because you don't want the child to spend a significant time in a place where it could later be argued that the child has become settled there.